Good morning, ladies and gentlemen. Welcome to my webinar, Anatomy of a Patent for Executives and Entrepreneurs. I'm going to do something a little bit different today. Instead of talking about startups and all the issues that they deal with related to IP, I'm going to do a deep dive into the patents themselves, right? My goal here is to empower you, to help you understand what that document is, right? I should have actually gotten a patent and held it up in front of you. But we all know what they look like. You can find them on the web, and we're going to look at some in detail today. Hopefully, after the end of this webinar, you will be able to look at a patent, understand really what the important parts are, how to read it and understand it, both from a point of view of your own IP and from the point of view of others' IP, right? So whether you're a startup person or a decision maker at a larger company, hopefully in the next 60 to 90 minutes, you will learn a bunch about patents and how to understand them and interpret them yourselves, right? Fingers crossed, that's what we're going to go for. A little bit about myself. I am a patent attorney and a partner at Ramon Law. I have been dealing with patents as an inventor for almost 30 years and as a patent attorney for about 20. I deal with patents every day. My practice varies from very early stage startups, two people with half an idea on an envelope, all the way to big Fortune 50 companies. Anyway, let's get started. One more thing before I go any further. Listening to this presentation does not create an attorney-client relationship between us. There's actually documentation and a specific one-on-one interaction that's required for that. So please don't consider me your patent attorney just by listening to this seminar, right? I will be giving my contact information as shown right here, and I will be giving it again at the end of the seminar. So if you have any questions, you can reach out to me on LinkedIn or send me an email directly, all right? Finally, questions. If you have questions, please hold them to the end and please put them in the question and answer tab. I will go through the question and answer tab first, and then if we have any more time, I'll look at the chat. All right, let's get started. There's a few preliminary, before we dive into the patent, there's a few preliminary things we should cover, all right? Click, good, that worked. Okay, what's patentable, all right? Pretty much everything. The real question is what's not patentable, all right? And the statutes say that any new or useful process, machine, thing of manufacture, composition, matter, or useful improvement can be patented, right? Of course, there's some carve-outs, right? Things that have been done before aren't patentable. Things that are obvious assemblies of things that have been done before aren't patentable, right? You can't patent algorithms, just a straight mathematical algorithm. You can't patent that. You can't patent some abstract ideas, okay? And you can't, of course, patent laws of nature, right? Discovering gravity doesn't give you a right to patent gravity, right? There's some gray areas in what's patentable. Business methods are a popular area for a while, and they've pretty much been cut down. If you have a patent application that's a business method, you're going to want to be very careful with it. You're likely to get put in a special class at the patent office where the examiners are brutal, okay? And you will really need to show something different and unusual and a different outcome that is really unexpected or that people haven't seen before. It's got to be more than just a different way of doing things that's simple or you could do with your mind or you could do it, all right? Software. Probably 70 or 80% of the patents I do are on software. Software can be very patentable, but it's got to do something, all right? There's a test called the machine or transformation test. In Europe, there's a technical result test, meaning it's got to do something other than just spit out numbers. Let me give you an example. A software application to calculate the risk on an option a financial instrument is not likely to be patentable, right? But software that sorts data or tags an image or helps guide a doctor to make a medical diagnostic, that's more likely to be patentable. There's some other areas, things like diagnostic tests. What if you're taking a purified piece of DNA and putting it into test equipment, right? This is something you have to sit down with your patent attorney and kind of go over these areas. But most of the time, people come to me with new inventions. We're almost always able to find some patentable material, right? Okay, that's first rule. Next, what rights do you have, okay? A patent is a right to exclude others. You can exclude importation, you can exclude manufacture, and you can exclude use, right? Patents can cover both the device and a process. So you could prevent somebody else from doing a specific process. This is all on a country by country basis. In other words, a US patent covers activity where the primary activity is in the US or the result of the activity is in the US. A Canadian patent covers Canada. A German patent covers Germany. A Chinese patent covers China. You're not going to get patents all over the world. It's prohibitively expensive. Your goal is to bottle up your technology and prevent others in at least your major markets, right? So it's a per country basis. Now, let's start the education process here. A patent is not a right to practice, okay? If I invent an improvement on an Intel chip, right? That doesn't give me the right to produce an Intel chip with my little improvement on it. Intel probably has gobs of patents covering their chip, right? And they have the right to prevent me from doing a manufacture or making the process of producing their chip, right? So even though you might have a patent, you may not have the right to do everything that's described in the patent because other people might have patents that also cover or overlay on part of that technology. So keep that in mind. A patent is not an automatic right to practice something, okay? Now, next slide, we're gonna start digging into the nitty-gritty. And usually, as you can see from my slides to this point, I try to keep my slides really simple. But we're going to talk about actually looking at a patent and reading it. So you're going to see slides here that are going to have a lot of text on them, and I apologize for that, but that's what a patent is. I will try to point out in detail what's important, and I'm not expecting you to be able to read everything on a page of a patent as I show it here. Let's first look at what are the basic parts of a patent, okay? In the beginning of the patent, there's a data page. That's the page you first bring up when you look at the PDF nowadays, right? There's a section called the specification, which is a bunch of writing, a big, long description. And the specification can be really long. I've seen patents that are hundreds of pages long. It's a nightmare, right? There's usually figures. The exceptions are sometimes you'll see something like a chemical patent that won't have figures, but almost always there's a figure in the patent. And then there's the claims section. And a lot of what I'm going to be talking about today is interpreting these different sections and telling you how you can extract information out of them and what to pay attention to and what's really important. All right, let's move on here. This is not a patent. Okay, and this is the first example where I'm showing you something with a bunch of text. You don't need to read all of this, okay? People sometimes come to me and say, oh my gosh, so-and-so got a patent on this. Can you believe it? And they hand me a document that starts off just like this. This is not a patent. This is a patent application publication. And on the second line, you can see it there. It says patent application publication. This is merely the publication of an application. There's a 90% chance that the claims or part of it's going to change before it turns into a patent, if it ever does, right? You can tell it's a publication other than it's an application publication because it says so on the top, on the second line of this document, right? And it gives a publication number, which starts with a year, 2019, and then a serial number for that particular publication, right? So when you see something like this, if it's something that concerns you or you need to talk to your patent attorney about it, one of the things you can do is you can go to the US Patent Office and look at something called public pair, P-A-I-R, right? So just type uspto.gov and go to public pair. And you'll actually be able to, once a patent application publishes, you will actually be able to go in and see all the correspondence that has occurred between the examiner, the patent examiner at the patent office, and the applicant, right? So that all is now public information. And you'll be able to see things like amendments to this application, what the examiner is allowing or not allowing, right? So these are the things that you'll be able to, once you see a patent application publication, before you panic, go and look at PAIR and see what the current state of the claims are, what the current state of this application is. There's a really good chance this particular published application here, this was abandoned. This application itself didn't actually become a patent, right? So it was not something to panic over on the first step, okay? Let's move on. That was the first step. Next, now let's look at an actual patent. Yay, here it is. This is a patent, okay? It is by a company called CloudSight, formerly CamFind, right? They changed their name. And this patent issued, we can look at the top line. This is the data page and part of the data page where you see the information about the patent. And I'm going to go through this little bit by little bit. So when you see this, you can figure out, oh, what was, what this is about. So on the top line, there's the patent number. This is 10,223,454, right? We're now in the 11 million range or more. So this is what, 13 million, anyway. The information on this page starts off with the applicant who applied for it, and then the inventors. These are the individuals that are counted as inventors on the patent, right? And that means that they, quote unquote, contributed to the conception of what's in the claims. And we're going to get to the claims later. The claims is kind of the end of my talk today, and it's like the exciting part. Okay, so hold on for the claims, right? So looking down the left column here, we see the signee. That's the signee, the owner of the patent at the time it issued, right? The ownership of this patent could have changed after it issued as a patent, right? And that isn't automatically updated on the cover of the patent. So if you want to find out who currently owns a patent, again, you have to go to uspto.gov, and there's a link there called Search Assignments, and you can search by a patent number and see who owns the patent. The ownership of patents is kept in a recording system, just like when you buy or sell a house, right? So if you buy a patent from somebody, you have to make sure that you record your purchase. There should be a purchase document and some assignment document that assigns ownership from one party to another. That actually has to be recorded with a patent office. If you don't record it, the person you bought it from might sell it to somebody else, and you'll be in have a big headache. Okay, so pay attention to the signee. If somebody tries to assert a patent against you, check to see they own it. That's kind of a nice step to do. So the next item is a notice that says the term of this patent has been extended by 182 days, right? There's a rule in the patent office that you're supposed to get your patent in a certain amount of time. And if the patent office takes too long, then you get a little bit of extra patent term. The term of a patent is 20 years from the earliest priority date. Okay, that's not from the filing date, but from the earliest priority date. And I'm going to explain that in the next line. So it turns out this patent gets 20 years plus 182 days. That can be really valuable sometimes. I have seen patents where the term extension is over 3 years, and it really makes a difference in the value of the patent at the end. The next line 21, is the application number. This is the number that was used track the application as it was in process before it actually issued as a patent. And it's really useful for looking things up on private pairs I talked about. You can search for things on private pair either by patent application number or by patent number, right? The next section, which is marked paragraph 63 here, is really important, okay? It's the priority information. So a patent can be a member of a family. If I file a patent today and I have a pending application and it takes 3 years for that application to issue as a patent, during that time, I could file what's called a daughter, right? It's a continuation of some type, right? You can have a continuation, which is a straight continuation, which means you haven't added anything to the disclosed material. Or you could have a continuation in part, which means you have added something to the disclosed material. A continuation in part application has a priority date that varies. That can depend on how much new material was added and what the claims are all about, okay? So this application, on line 22, you can see it was filed on June 10th, 2016, right? But according to paragraph 63, it's a continuation part of another application that was filed in January of 2015, and then it says continued. And in the next slide, I'm going to show you more of that, all right? But let me finish up on this slide first. So the next lines, paragraphs 51, 52, 58, that's just classifying the subject matter of the patent and who, how the examiner did their search, right? 56 is important. That is a list of what the examiner cited against this patent application as it was being examined, right? And so if you know of a piece of prior art that's really important, that's not in that list, okay, then it might be you have some good prior art to challenge this patent. But if the prior art is in this list, it means the examiner considered it, and you have to look at actually the history of the patent, again, on private pair, in order to figure out exactly what happened, all right? The abstract, typically considered part of the specification of the application. It can be misleading, right? There's no rule that an abstract has to really represent everything that's in the application, right? Okay, I'm going to now move to the next page, and I'm going to show you the continuation of paragraph 63, the related applications, and of paragraph 56, which is the references cited, okay? And especially pay attention to paragraph 63. This is the one that's talking about the continuation applications and the priority claims, right? Okay, here it is. There's more. So here, unfortunately, you can't see my cursor, but on the right side, there's a long list of related US applications, right? And I see from this that it goes all the way back to May 1st, 2014. Okay, so this patent application is a member of a family that traces its priority back all the way to May 1st, 2014. So that means that this patent is going to expire 20 years from that date, plus the 182 days, okay, if they pay all the maintenance fees and stuff, right? If you want to have prior art against this patent, right, if you want to try to challenge it, it'd be great to have stuff before those early dates, right, before May 1st, 2014. And of course, there's lots of, as you can see here, there's lots of intervening patents. There's a whole group of applications that were filed together. This, it means that different material was added to the application on different dates. If you want to challenge this application, you want to have a prior art reference that comes before whatever date new material, the relevant material was added to this application, all right? So there's more list here of other references cited. As you can see, the examiner looked at maybe 30 different applications, all right? And the the ones with little asterisks by them are ones that the examiner actually discussed. Okay, so that's the data section of a patent application or of a patent. Okay, the important things that you get from it are the filing date of the patent application and the priority dates. You have to look at when the priority dates are. And if it's a continuation in part, you have to look at what was added in each different stage of the application. It means that somebody's added new material to the specification, and they only get credit for the date that they added it, not the earliest priority date. If I'm confusing you, talk to me afterwards. Thank you. Okay, that is the data page that we always look at, all right? And if you see a patent, one little thing I want to point out is that there's maintenance fees to be paid. And very often they don't get paid and the patent gets abandoned, right? Which means it's no longer enforceable. So another thing to check if you're looking at a patent is, oh, is this patent still in force? If somebody hasn't paid the maintenance fees, then the patent becomes abandoned, right? All right, moving on. We next have figures. Okay, so I picked out 3 different figures from this particular patent, and they represent different things. So this is a software application, right? We're doing image tagging. It's about taking images like this image here of a Starbucks cup and identifying what's in the image and reporting tags back. Okay. There's I'm showing you 3 different types of figures. And the first one, figure 1, is a system figure. For software, it's usually a block diagram like we have here, right? There's an image processing system and a network and a bunch of clients, right? Inside the image processing system, there's different logic modules, which we're gonna explain in the specification and reference in the claims, okay? That picture in this particular patent will somewhat correspond to claim 1, and we'll see that in a minute, okay? Figure 2 is just an illustration to kind of inform the reader, okay? We're talking about, here we have an image, right? We have a part of an image that has a logo on it, the Starbucks logo. And it's also a white cup, right? So the image tagging software, if you look at the top of figure 2, has come up with an image tag that says white Starbucks coffee cup, which was back in 2016 was a pretty good tag, right? It's not just cup. Right. It actually has used the logo and figured out that it's a coffee cup from Starbucks. All right. So this figure 2 is used to help explain how the software works and how the different logic modules work. Part of the secret sauce in this patent was getting that nice grammatical tag, not just a single word like cup or logo or white, right? But actually making a nice string of a tag. And we have different images, different parts of the image that the client or the holder of the patent would analyze, and then they'd rank those parts. Like, what's most important, the fact that it's a white cup or the fact that it's got a Starbucks logo, right? That was part of the secret sauce. So figure 1 is a system diagram, which shows the logical elements. Figure 4 here, I think there was like 13 figures in this patent. I don't remember exactly, but there's plenty more than this. Figure 4 is a flow chart. It's a process, a method diagram, and it corresponds somewhat to one of the claims that's a method of doing something. Figure 4 lists a series of steps, starting with receiving an image, receive a subset of identifications within the image, receiving some data, analyzing, etc. And the claim that corresponds to this figure is going to be a series of steps. It's a method of doing something. It's really helpful to have figures that are system diagrams separate from the method diagrams. We don't want to mix them. We don't want to have a system diagram where you're talking about the data flow so much, right? That makes analyzing the patent more difficult. In the description, if you read through this patent, you'll see that, for example, receive image step 410 is probably in the description of that step, that it refers back to the system diagram and says, oh, that's done with IO 130, right? So in this particular patent drafter, me, I present the system diagram first, and then when I'm describing the method, I refer back to the system. And I can talk about how the data flows from those different system elements in the method diagram. All right, so there's figures, and figures are really helpful. They give you a good idea of what the patent's about. Look for both system figures and method figures. If this patent had been on a gear system or an airfoil for an airplane or on a barbecue grill, right? You probably would have not had a block diagram like this. You would have had mechanical drawings of the device, okay? I do, 20, maybe 30%, 20 or 30% of the patents I do are on devices like that. Recent ones, hydroponic growing beds. Here's a picture of the growing bed. Here's how it looks. Here's the different layers of material, right? That's how we would do it for a actual mechanical device other than a piece of software. All right. Next step. How am I doing on time? Okay, good. So I'm worried because I have a lot of slides. All right, folks, here's this next part. Again, I don't want you to try to read this. I'm trying to show you what the parts of a patent application are. These are a couple of pages of what's called the specification of this patent application, right? And the specification of a patent is divided into columns, right? And here I'm showing you column 1 and 2. We've skipped a few pages, and I'm going to show you columns 7 and 8. When you refer to part of a patent application, you refer to the column number and then the line number. So if you look in the middle of each of these pages, there's 5, 10, 15, 20 lines are numbered in by 5, right? So I might refer to column 2, line 5 to 10. That's how you reference a certain section of a patent application. So the specification can describe lots of stuff, right? And one of the things that happens with people is they'll come to me and they'll say, oh my God, somebody got a specification on this. This is what people have been doing for years, right? We've all been doing this. How could they get a patent on this? Patents are stupid, oh my gosh, right? Well, the specification is designed to support and explain the invention. And that means that it will include a lot of stuff that was there before, right? But somewhere in there are the magic sauce, right? There could be a couple of paragraphs where it really explains what's new about this invention that wasn't done or wasn't obvious over what was done before. So reading the specification does not tell you what is claimed in the patent. It doesn't tell you what's covered by the patent. The specification is just a description of the technology, right? And it could be that one specification is used in 5 different patent applications and issues as 5 different patents. What's different about those patents is the claims will be different. And as I've said, the really exciting part of this presentation is going to be the discussion of the claims, because that's what matters, right? So again, the specification can include lots of stuff, right? And it is designed to support what the claims are all about, to explain the claims. Right? The specification includes, again, a cross-reference to related applications, which should have corresponded to the, but not quite necessarily corresponded to the prior priority claims from the first page, right? There's a background and a summary. Reading the summary is useful, right? It should give you, hopefully gives you a good idea what the patent is about. There, if you look at the top of column 7 here, that's part of a listing of what the figures are, right? There's 16 figures in this particular patent. I showed you 3 of them, right? And there's the brief description of the figures, just kind of is supposed to give you a very short idea of what each of the figures represent. And then there's a long detailed description, and this detailed description goes on, I don't remember, this is like a 30 or 40 page patent, right? And hopefully the detailed description will discuss everything that's in the figures. There are numbers. So if you look in column 7 of here, just below the heading detailed description, it refers to figure 1, and it talks about an image processing system 110, right? So you should be able to look at figure 1 and see image processing system 110, okay? That's how we keep track of what we're talking about in the patent application. And the patent office makes it convenient for you because they make all those reference numbers bold, right? If your numbers in the specification and your drawings don't quite match up, the patent examiner is supposed to catch that and make you fix it, right? So again, the description is not necessarily what the patent covers, it's what the patent is about. Now we're going to get to the important part here, the claims. Ta-da, all right? So again, I'm not going to expect you to read all the words here. I know that it's small. I just want to, but I got to talk about these claims part. The claims are the part of the invention that the patent, that the inventors and the owner of the patent thinks that they own, right? This is the part that they think is their invention, right? So the claims are everything, okay? They matter more than anything else, okay? It's the language of the claims, and what we're going to do is I'm going to talk about right now about how to read a claim, right? And hopefully that's the most important thing you're going to take home from this webinar, right? So claims are numbered, okay? In the figure I have right near here on the left side are claims 1 to 9, and I've cut off part of the page, so then you see claims 15 to 30 on the right side, in the right-hand column. All right. So claim 1 is a system claim, right? It's describing the physical apparatus, right? And this is software, so they're logic elements. And the logic somewhere in just above the section of claim 1, I'm not expecting you to read the text, but it says that the logic is either hardware, firmware, or software stored on a non-transit computer readable. It's a physical device, right? So the logic in software, very often we claim logic elements, right? And claim 1 has 1, 2, 3, 4, 5, 6 main elements in it. It's got an I/O, right? Just your communication port or antenna or whatever. It's got an image tagging logic, okay? A token ranker, a search engine, and response logic, and a microprocessor, electronic processor, right? Those are the main elements of the claim. In order to infringe this claim, somebody has to have every one of those elements, okay? And not just the elements, but the elements as described word by word in this claim. So when I look at a claim and I want to analyze whether some product infringes or not, I go phrase by phrase. I actually make a table. I go phrase by phrase through the claim and say, do these people have an I/O that is configured to communicate an image over some network? Yeah, probably, yes. Do they have image tagging logic? Yeah. And then I drill down into the details of every word in that paragraph there about image tagging logic. If there's something in that paragraph that the product you're looking at doesn't have or doesn't do or isn't inherent to it, then the claim is probably not infringed, okay? The other side of this is the claim valid, right? The two questions you want to ask about a claim is, am I or somebody else infringing it, and is it a valid claim? So in order to be a valid claim, there has to be something in this claim 1 that's either original, right, never been done before, or not, and non-obvious, okay, not an obvious extension, right? We're not changing something that was painted red and now painting it blue, okay? That's not going to make something patentable. So there has to be something in here that is unique. Obviously, it's not the I/O configured to communicate an image. That's been around for ages, right? So people come to me and they'll say, oh my God, how can they patent an I/O? Well, that's not the part of this claim that makes it different, right? People have had I/O for a long time, right? Image tagging logic has been around in general. I'm not going to drill down to the details of this particular image tagging logic. One of the things that could have, and I'm not saying, haven't looked back at the history of this patent, but one of the things that was likely to make this claim patentable was the token ranker, okay? So the token ranker is the thing that goes through those images and says, okay, I found a logo, I found a white cup, I found, a napkin. What is important about this image? And ranking the different tags, okay? And then the software says, okay, I've seen an image and I figured out what's important about it. And now I have a search engine that's going to use those tags to return a search result. So one of the figures I didn't show in my slide of figures was actually a search result. You take a picture of this white coffee cup and you get an ad for you do a search, you get a ceramic cup, you get ads for Pete's Coffee. That's how this thing works. It's picking out the element of the image that was important to do the search on, right? And the technology behind this has all kinds of interesting AI feedback and so on. So it's likely, or it could be, and again, I haven't looked at this patent in ages, that token ranker and the search engine that uses the results of the token ranker is what makes this claim, what made this claim allowable, okay? So you have to go through, again, phrase by phrase of a claim to see if it's infringed, right? Or if you're analyzing prior art, can you find prior art that has every single element in the claim, right? Let's think about what this means for a minute. In order to infringe a claim, some product has to have every element of the claim. That means, important thing here, that means that the more words in the claim, the narrower it is, right? This is a pretty reasonable claim. A claim can have just 2 lines or 3 lines, right? So that means there's not many elements in there that have to be satisfied in order to infringe the claim. That's a really broad claim. I mean, just looking at the word count, right? And the number of elements that have to be satisfied. So if you look at a claim, if you pick up a patent and you look at the claim and it's 1.5 columns long, right? It has like 90 lines in it. What does that mean? It means it's really hard to infringe that claim. Somebody would have to have every single line, element, every phrase in there in their device in order to infringe that claim. And sometimes people come to me and they say, I've got a great patent. I want to enforce it. Everybody's infringing my patent. Look at it. And I open up the patent and literally it is a 1.5 column claim. And they say, everything I do is in that claim. Everything. This guy does. And the patent attorney, their patent hasn't explained to them that it's the narrowest claim, in the United States. I mean, you would have to work so hard to infringe that claim. You'd have to exactly copy this person's product. So claims with lots of text are narrower relative to claims with just short text. If you see a claim that's only a few lines long, that means in order to invalidate that claim, you need to find prior art that, this is some publication or presentation or something that came before the filing date of the patent application. It's easier to invalidate broad claims, right? But then they cover more. So there's a trade-off, right? Is it a claim that has lots of detail in it is harder to invalidate, okay? But it's also harder to infringe, right? So claim 1 is what's called an independent claim, right? It says a search system comprising. Claim 2 is called a dependent claim. And it's called a dependent claim because it is also dependent on claim 1. Claim 2 says the system of claim 1, wherein and a whole bunch of more limitations. This means that you're making claim 1 narrower. Each dependent claim should make narrower the claim that it depends from, right? So claim 2 adds like 5 lines of new limitations to claim 1, right? And this is really useful because if you litigate this patent, there's a chance that claim 1 gets knocked out, but claim, because of some prior art or some issue, but claim 2 still stands, right? So then you get a backup. So when you have a patent application issue, you have a bunch of independent claims and then dependent claims that depend therefrom, which narrow the case. Looking at claim 3 here, we have claim 3 that depends from claim 1, and then claim 4 depends from claim 3, right? And 4, 5, and 6, and you can read yourself, right? So each of these claims is adding a different set of limitations to the limitations that are already in claim 1, okay? Let's see, anything else I want to say about that? Okay, I'll send me questions in the Q&A and I'll get to them if you have them. Claim 15 is a different type of claim, right? It's on the top of column 2 here. It starts off, and this is called, the first line of the claim is usually called a preamble, a method of processing an image, the method comprising. And then it lists a series of steps, okay? So this is a claim to a method, and a claim to a method can be really valuable because it means that every time somebody does the process, they infringe, okay? Let's say you had a patent on creating an AI drawing, right? There's a piece of software, that might infringe, but people are using the AI over and over again. So there's lots of infringing events that might be helpful in litigation, right? So typically a software patent will have system claims and method claims. Right? The method has the steps of determining a weighting of tokens, of image tokens, receiving an image, identifying image tags, parsing the image tags, performing a search using the tokens, and sorting the results. Okay, and again, it's probably the ranking that, and again, I haven't looked at this in a while, but it's likely that it's the producing a bunch of different tags and ranking them that made this patentable. Okay, so in order to infringe this method claim, somebody has to do every one of those steps, including all the little details in each of those paragraphs. Okay, and just like the system claim, the method claim has a bunch of dependent claims hang off of it. Claims 16 to 30 all depend either directly or indirectly on the claim 15. There are other types of claims. There can be a claim on a kit. There can be a product by process claim, which is a method of producing a product having certain features by the method of so-and-so, right? Those tend to be narrow. The most common claims you're going to see are system claims and method claims, right? Let's see, what other things are important here that I want to talk about? The words in the claims, all right? So let me pick a word out here, token, all right? Both the method claim and the system claims have the word token in them, right? So what's a token, right? You have to look at the specification, right? That's the reason for this whole specification thing, which could be, in this case, was probably 30 some pages, right? The specification explains the phrases and the limitations used in the claims. If this patent never, in the specification, never mentions the word token, then there's a problem because token can mean a lot of things. Token can mean something that's really minor. It can mean a coin you put on a machine, like at a game arcade. In this case, we're talking about a word that identifies something we're probably talking about a word that identifies something in an image, right? In a software, a computer sense, what a token is. So the specification has to explain everything in the claims. When the claims are analyzed, you first consider what's the normal use of the word, right? And then you consider what's in the specification, right? To help define what that word is. And the meaning of individual words really matters a lot, okay? In a patent litigation, there's a whole process where the two sides argue about different phrases in their meaning. It's called a Markman hearing, right? And a judge will issue an order saying a switch means this, right? And a token means that, right? So the specification has to have enough in it to support the meaning of all these claim limitations, right? That's why you have to have a good meaty specification. The specification can have lots of other material that's not claimed, right? This patent only covers what's in the claims. And again, as I said before, that same specification could be used in another patent application and then patent with a different set of claims, what's called a daughter application or something, a sister application. So again, remember, patents and their applications can be members of families. You can have different sets of claims on the same specification or on slightly different specifications, right? They can all form a family, which is really common. I have seen families with dozens or maybe even 100 different members, right? You start off with one core idea, and over the next 5 to 7 years, build a huge family of patent applications. All right, let's see, anything else here? Keep in mind that if you see stuff in the specifications that's not, in the claims, that's not supported in the specification, that is a real weakness. It's an indication that the patent's not very good. If your specification only has 5 pages, that's likely to be a problem. Hopefully, like here on claim 1 and claim 15, those are going to somewhat correspond to the drawings. So in figure 1, there is image tagging logic, right? There's a token ranker. Those are all elements within in the block diagram of figure 1. And in the same sense, the steps of the method claim, claim 15, hopefully are in a figure somewhere, right? Let's see, anything else? Avoid huge, giant claims. That is a big mistake. Let's check my time. I think I'm going to be, that's kind of covered everything I want. Let's go on. I'm going to have a couple more slides, and then I'm going to dive into the questions and answers. All right. Okay. Now that we've talked about this, I do have to go back and say, why do all this? Why do patents? Okay, and it really depends on who you are and what your strategy is. If you have a plumbing company, you're more likely to do trademarks, okay, or something else. The idea behind patents is to increase the valuation for a startup. The idea behind patents is to increase the valuation of your company so that every time you raise money and on your exit, you get more, right? If you're a startup, you're the little guy in my graphic here. And that means that you want to have a portfolio that conveys value to your investors and your acquirer, right? And that's my goal as a patent attorney, is that every time I file a patent application for somebody, I more than pay for myself an evaluation of the company, right? If you're the big guy here, right, you want to worry about other big guys. You're not you might do a lot of patent applications, but you're not necessarily dependent on each individual one. For startup, the first few patent applications could be the jewels of the company. If you're Intel or Apple, you have thousands of patents and they overlap a lot. You're more of a we want to have lots of patents, but we don't want to spend so much in each one, right? It's more of a budgetary consideration. For those big guys, they have to worry about each other, right? There are often battles between the Facebooks and the Apples and the Samsungs and so on. So, they develop big patent portfolios for that reason. Some companies, I don't know if they still do it, but IBM just used to have a publication system where if they developed something new, I mean, they had so many new inventions, they just had a basically regular journal that went out every month with all their new ideas, creating prior art, so other people couldn't patent over them, right? So those are the reasons. And again, it depends on the type of business you have. Do you have a company? Are you a CEO of a Fortune 100 company, right? So your IP will have a different purpose than if you're a startup. I do want to point out that litigating patents and actually enforcing them is a really expensive project. It can cost millions of dollars, right? Taking a patent litigation all the way through trial, $2 to $4 million. So it's not a really good thing. If you're a startup and you're all of a sudden involved in patent litigation, you're probably now just a patent enforcement company because you don't have time or money for anything else. So that's not the best, that's not necessarily always the best route for you, right? What you put in your patents will have really is dependent on your product pipeline. Your patent attorney should really know what the plans are for the company, what your goals are, what you expect. Remember, they're going to be writing a patent application that's going to be valuable maybe 7 to 10 years later. So you get, one of the nice things about being a patent attorney compared to being an engineer, I was a CTO for most of the 90s. And I can write on a patent application in 20 hours what it might have taken me, 6 to 12 months to engineer. It's a lot more fun, but you get to think way out of the box. You're going to try to put ideas into your patent application that are going to be valuable and useful 10 years later, right? So that's kind of a fun, futurist, I would say, idea. Okay, that's it. I have one more slide, Kink, and I'm pretty good on time. Okay, Ramon Law, about myself. We are a law firm of about 200 attorneys. We are a semi-virtual law firm and have always been that way, meaning we do have offices. For instance, I am associated with our office near Lake Tahoe, California, and our office in Menlo Park, California. I'm a California attorney and a patent attorney, but we have offices around the world. Being a semi-virtual law firm, that means our offices are primarily conference rooms and maybe a sprinkling of admins. Most of the attorneys work from home or in very nice places, wherever we decide to be on a particular day. So that also means that our cost structure is really good. And we're kind of unique that we're not a big giant pyramid like a lot of other big law firms with dozens of associates, and all the partners ever do is manage work by junior attorneys. We are very top heavy. Most of the attorneys at Ramon have at least 20 years of experience. So that means you get somebody who's probably been at a big law firm and was tired of the agony of that that experience and has come to a firm where they actually get to practice law and work directly with clients. At Ramon, you won't have a first or second year associate doing your work somewhere in a back room. And that's us. We are in 14 countries, so we support clients all over the world. It's a great place to do. I'm I'm mostly sometimes in the San Francisco Bay Area, but mostly in the Reno, Tahoe area. That's it. I'm now going to move to the questions and answers. And I'll probably, there's 12 open questions I see. After that, I'll quickly skim the chat, see if there's anything else. Here is my email. Don't hesitate to email me. That is my work number and my LinkedIn. Please connect with me on LinkedIn. I'm now going to head over to the questions and answers. And the first one is from Anne. Thank you, Anne. If algorithms are not patentable, how come so many AI algorithms are being granted patents? Well, I do a lot of AI, and the example we just talked about today, that I used, the image tagging, was an AI company, right? It wasn't their core neural network. I mean, the basic structure of their neural network. That did have some tweaks, but they chose to keep that as a secret, right? That's not what was patented. What was patented is the idea of dividing an image up into different parts, identifying, making tokens representing each of those parts, and then ranking the tokens and figuring out which of those tokens are useful for doing a search, right? So very often in AI, it's the gathering of data. How you use the AI that becomes patentable. My favorite areas are where you have an AI and you manage to get a feedback loop. So I've done a patent, for instance, in healthcare, where the more the AI was used, because it had an automated feedback mechanism that was kind of unique, the more the system was used, the smarter it got. So it was kind of self-training. You got good data. The company that did the patent we talked about today, they started off, they built an algorithm that looked at an image and decided how accurate their AI-only analysis was going to be. And if it wasn't going to be that accurate, it went to the Philippines and a human typed in a tag and then send it back. And they did that a lot. That company has about 750 million high-quality tagged images, one of the largest databases, right? And their earliest patents were on this process of deciding whether the image should go to an AI or a human and how you would use it, and then the feedback from the human to further train the AI. So they have one of the best AIs, right? As you can see, 6 years ago they were making whole phrases as tags, not just single words. So when we talk about, and I do lots of AI, it's usually how the AI is used that becomes the subject matter of the patent. Right? Sometimes I have genius inventors who are actually the people who are developing new ways of doing neural networks, segmenting them in a certain way, figuring out how to pass high-speed data through them to make them really fast. I had a client at one point that was doing tracking of advertisements on the internet, and we're talking about hundreds of millions of ads, and putting that through an AI was a speed issue, right? So they had invented ways of making basic architecture of AI faster, but usually people are taking off-the-shelf AIs and using them in new ways, just like you would take an off-the-shelf spark plug and use it in a new engine design. It's just part of the mechanics, right? All right, that was Anne's question. The next question is from Arun. Thanks for this material and context. If a piece of software has been made available with a permissive open source license, does that imply a general right to practice from a patent perspective? It depends. If somebody takes a piece of software and puts it up on the web and makes it open source and says, here, come and connect to my software, you can download it, here's the APIs, or however it's open source. Well, were they the patent holder? So if somebody else has a prior patent on this, that open source license isn't necessarily cover the patent. It's the patent owner that has to provide the license. Okay, so there's an issue here. Open source licenses can be tricky. It's preferable that you have an attorney look at it. If your employees are using open source material, you really need to look carefully at the license, because it can require, for instance, that you make all your software open source. This happened to a former president of ours a year ago, where he tried to launch a social network, and they used an open source software that required that their entire software be also made open source. And there was no way they were going to do that. So they had to kind of start from scratch and delay this release by months, right? It cost them a lot of money. Bad lawyering, somebody got bad advice. So yeah, if something has an open source license, and I've done patents for entities that are making their product open source, it has to be the owner of the patent, the current assignee, right? You can't just make something open source and trample over another third party's patent, right? Okay, the next question is from David. Hi, David. I've already ran USPTO, Google, and WIPO on search, nothing like my system for electrostatic deposit control for water-based cooling systems. Okay, it's a breakthrough worth billions just for the data center. Or we have a provisional. What do you suggest to do next to keep attorney fees down? So this is talking a little bit about the business of patents. Right? Provisional applications, we didn't really talk about. Some of my other lectures talk about provisional strategy and how to bootstrap an IP portfolio. Provisionals can be done really cheaply. They're less formal. And one of the weaknesses is, I talked today about how the specification has to have enough in it to really support the claims and explain the claims. Often with provisionals, they're thin and they don't either have enough. There's stuff missing there, so you're not fully supporting future claims you have. And that means that your priority date for your claims are the non-provisional filing date, not the provisional, which is an issue. So for the person who's got a provisional, once you file that starts the 1-year clock. And that means you want to go and raise money. You should file and the next day be doing pitches and looking for more improvements, because you're going to file a second provisional in a few months. You need to try to raise money. That should be the strategy. And if you don't raise money in a year, maybe the idea isn't getting traction and there's a reason behind that. You either need a different person doing the pitches, or a better business model, which matters a lot, a better team. For some reason, you're not raising money. You've put a whole year of your life into this project and nobody's willing to put $500,000. Maybe you should move to another idea. But so I'm not saying, David, your idea is not good, but yeah, you do want a patent attorney to do your non-provisional, because that getting the claim wording and making sure the specification is strong enough is really important. Find somebody who's used to working with startups, because they work on a budget, right? So I'll do a provisional application for $2,500. If a company gets funding, a non-provisional is probably more on the order of 18,000, right? If the company doesn't have money yet, there's a couple of alternative things we can do. You can refile the provisional depending on whether you've made things public or not. You can file what I call a lifeboat application, which is a really sloppy, horrible application that you hope never sees the light of day, but you keep the priority dates alive, right? While if you're just on the verge of getting money in. It takes business planning. Yeah, so hopefully that answers your question. One more question. So David, one of the places you might look for money is the Clean Tech Open for your water-based cooling systems. If your system saves energy and things like that, that's a possible incubator that will help you go ahead. Okay, Anne, we're going back to Anne. Anne asked what the B2 number means in the patent number. That just means it was the B2 publication of the patent. So it might be there was an error in original patent publication. It was published as an application first and then later as a patent. That's not actually part of the patent number, and you don't need to keep the B2. It's just the one number that really matters. So if you go to Google Patents, you search just using the number, which is in the 10 millions now, right? Okay, Brad is asking, what's the URL of this private pair website? So its pair is PAIR, first of all, and go to uspto.gov. That's the US Patent and Trademark Office. And you will find there a whole bunch of links. There's something called private pair and public pair. You're going to be using public pair unless you're a registered patent attorney. Private pair is for looking at. I use that to look at my the applications I've filed for clients. Okay, so public pair is the one that everybody can see. And once a patent application publishes, it gets posted on, or it issues as a patent. It gets put on public pair. And then you should be able to search by either the application number, the publication number, or eventually the patent number. Of course, not all patent applications turn into patents, and not all patent applications publish, right? There's a choice somebody has at some point. And if you file outside the US, you have to publish. But if you don't file outside the US, then you don't necessarily have to let your application publish until it turns into a patent. And then it publishes when it's on the day it's patented, right? So you can look at public pair, and I probably said private a few times, but it's public pair that the general public has access to, and it's on the front page of the Patent Office website. Ben is asking, are there any specific requirements for software or process workflow diagrams? Should I use some specific notation like, no, there isn't. It's important that it be clear, right? So you want to be really consistent. So if you have an element like token identifier 110, right? You want to always use that phrase. You don't want to call it identifier 110 sometimes, a token 110. You want to be really consistent with your terminology. Use numbers that correspond to the drawings. That helps. With mechanical systems, if it's gear or gear notches or whatever, be really consistent. That helps the writing, and your patent attorney should be watching that. I recommend that even if you're doing a provisional, you have a patent attorney help you with claims and review your application, give you feedback, participate a little bit to keep the, but keep the price down, right? A provisional application can be a slide deck, right? So one use of a provisional application is if you have a paper you're presenting at a conference, or you're going to go pitch your company publicly at an event, or do a public demo at a conference, at a trade show of some sort, you might file a provisional application that includes your slides and maybe some requirements documents or some, a little bit more material. And that prevents the date of that provisional filing is before your presentation, right? And that prevents your presentation from being prior art that can be used against your later patent application, right? That provisional doesn't have really enough in it to support a good patent application, but it prevents that specific presentation from becoming a prior art that can be used against you. So often I'll get, from a university, here's a scientific paper that's going to publish next month. File this as a provisional, right? And that way, when the paper does publish, that publication is not used against a later patent application. Okay, that's one of the uses of a provisional. Okay, so provisionals can be really informal. They can hand drawing, right? Screenshots from your app, things like that. A full patent application, I do advise working with a patent attorney. There's standard headings, right? And you can look this up on the Patent Office website that I gave you. We'll give you, some guidelines. These are the sections you need to have. This is how to number claims. But there's thousands of pages of instructions. So the thing is to find the right stuff. That's where the attorney comes in. Yeah, you ask a little bit more about if you have informal drawings, are they too ambiguous? So it depends on the specific application. So in the case that I showed you, I had a block diagram, right? That's pretty ambiguous, but it's software. And each block represents some piece of software in memory or hardware or firmware or logic or chip. The I/O is probably an antenna or an Ethernet port or whatever. So you want to cast things in a certain way. Here's another example that, yeah, never mind. Okay. Yeah, so if you have a drawing that you think is going to be ambiguous, write about it in detail in your specification. Explain it, right? This is what this element does. Another good sign between a good patent and a not so good patent is a good patent will give you lots of alternatives. It will say, here is the 5 different ways of generating tokens in the case we just talked about, right? So it doesn't just focus on the one implementation you plan to do, but you also cover 3 or 4 different alternatives. And you'll see language in the patent that says, in some embodiments, this, or optionally this. And those are all different ways of doing things that are optional. And they're in them being in the specification adds breadth and meaning to the terms in the claims, okay? So if I say a token identifier, and I've only described in the claim, if I say a token identifier, and I've only described in one place in the specification and one way of identifying tokens, that token identifier might be considered narrowly just that way of identifying tokens. But if I've described a series of ways of identifying tokens, right, then that whole class, that whole genus of approaches can be imputed into the term token identifier, right? So how I've presented things in the specification can really have significant meaning on the scope and the meaning of the words in the claims, right? So a meaty, thorough, detailed specification, the more meat, the more stuff you've got in there, the better off you're going to usually be, right? Unless you go too far, right? All right, that's next. I'm going to Jean Pears. Can a patent prevent someone from building your patented device or process for their personal use? Yeah, but are you gonna, okay, so let's say you've realized that somebody on the street has made a copy of your system and is using it in his garage. Well, you could sue him under the patent in federal court. If you got a good litigator, you might, it's straightforward. You might only spend $50,000 to $100,000. Yeah, I've seen very efficient suits be cost the patent holder only $250,000, right? So you probably wouldn't go after somebody who's just using it for personal use, okay? If you're going to litigate and enforce a patent, there better be, you ought to have deep pockets, or there's got to be a lot of damages in the end so that you can persuade an attorney to take it on, right? I have one patent litigation case. I'm usually a patent prosecutor, which means somebody who writes patents and writes patent applications and gets them out of the patent office's patents. But I do have occasionally litigation cases. I have a litigation case now that has substantial financing behind it, right? There's an investor who's put in millions of dollars to pay for this litigation because the rewards could be high, right? So that's the, so you probably wouldn't sue somebody who's using something for personal use. There's other areas, other exceptions. In the US and in Europe, you can't block a doctor from providing medical care, right? In Europe, specifically, methods of treatment are not allowed to be patented. In the US, you might be able to patent something that's a method used in healthcare, but you're not going to be able to use the patent against an individual doctor treating a patient. And that's considered, for the benefit of society, the patient needs to get their medical care is more important than your patent rights, right? So in the law, there's small exceptions like that. One thing I should point out about use is, if you have an app on your phone, right, and you show this at a conference or you show people, the public use isn't just the part that's on the phone, it's the whole back-end server. Everything that supports what's on the phone, that impacts and influences and makes the interaction and appearance on the phone the way it is, all that is considered public use, even though the people at the trade show have no idea where your server is, they don't get to see it, or they don't get to see the internal parts of it. That's still part of the public use, okay? Okay, next, Ben. Is it okay to use potentially ambiguous terms and abbreviations like IO in the example without their definition in the footnotes or some kind of glossary of terms? So, like IO, I used in that patent that we talked about, there was an IO. Somewhere in that specification, it talks about the IO and it gives a list. This IO could be, include communication ports, routers, Ethernet, Wi-Fi, whatever. I have a standard list, and the logic that supports that. Okay, so that's if I use a term like that in the specification, it's important that I define it. I mean, if I use it in the claims, anything used in the claims has to be defined in the specification. So one thing I do, or good patent attorneys need to do, is when you're about to file your patent application, you go through the claims and you grab every phrase and do a search on your spec and make sure you've discussed everything enough, right? Because you miss something that's you can get in trouble. I mean, because it can be interpreted in ways you never expected, right? So the other thing is you get to define your own terms, right? So you mentioned using, in your question here, you mentioned using a glossary of terms. So sometimes, not all the time, but sometimes I'll actually have, rarely, but sometimes, a section at the beginning of the detailed description that defines 3 or 4 key terms, right? As I'm using them. You get to adapt terms to your, to define what you're using, right? So you might say a camera is, for the use herein, a camera is meant to be a digital camera, right? Including a lens and a photoreceptor. I mean, that might be a definition you use. I say in my patent applications, I refer to logic. I talk about logic elements. And near the end, usually somewhere, there's a statement that says the term logic herein represents systems or devices that include hardware, firmware, or software stored on a non-transient computable medium, and can include circuits or a microprocessor. And right, there's a standard boilerplate that I use to define what, to make the logic a piece of hardware, right? I don't let logic be something in your brain. I actually define that term. And I've had examiners challenge me on that, and it's like, no, I've written hundreds of patents with this. I know how to respond to this. No, this is how I've defined it. You can't, and the examiner's not allowed, not supposed to, take a term that you've specifically defined and bend that too far away from your definition. So it can be helpful. Yeah, you can define it anywhere in there, and you got to be careful though if you want to. If you have a lead brick and you want to call it a feather, the examiner might object to that, right? So if throughout your application you refer to the feather, and the feather gets launched with a catapult, right? No, you're talking about a lead brick. You don't really want to do things that are too misleading. I've seen patent applications where you have no idea what they're talking about. There's these terms that are kind of ambiguous. In the end, there's a little table of this term means that, and this term means that, and then you got to go, oh, go back and read it again with the definitions in mind, and that's just trying to obfuscate what the patent's about, right? Make it hard to search or hard to find, but rarely a good practice, right? Because somebody's going to attack it just because it's not clear, right? Then you're really depending on the terms, and you can't borrow the ordinary meaning. So as a patent attorney, I know I'm getting, let me check my time. Okay, as a patent attorney, I collect dictionaries, right? I have, when I had an office, I had a full 6-foot bookshelf with anytime I go to a used bookstore or see something, I buy the dictionary of aerospace, the dictionary of fables, the dictionary of angels, the dictionary of dirty jokes, right? And so I use those, and I'll argue with a patent examiner a meaning of a word and I'll find a reference, the dictionary of technical plumbing terms, and I'll grab that out of my bookshelf and I'll take an image of it and send it to the examiner and say, this is what the word means in this field, right? And that's important. So you don't want to go terms that are too far from the ordinary meaning, because then you can't use that dictionary term, right? You want to know the term you're using. Now, I'm going to give an example of one where it didn't go well for me. So I had a device that was a button, right? It was a membrane switch. You know, you push buttons like on the old iPhones, right? You push a spot, and the little piece of outer material touches the back, goes through a little gap and touches the back, right? That's a membrane switch. And I had a backing plate between the outer layer and the inner layer, right? And this was an RFID device, but so I had this membrane switch, and I had I described the in-between layer, right, that has little holes in it, the spacer, as essentially covering the entire plate, okay? And I used the word essentially, and I meant, you know, it doesn't have to cover all of it, but pretty much all of it, right? And the examiner comes back and no, essential means, essentially comes from essential. It's only covering the required parts of the plate, okay? And, you know, eventually I gave up. But yeah, that's an example of a patent, you know, I guess I wrote that back in 2004. 2005. So it was, yeah, I needed a better term, and that was a mistake. I should have either used that term and specifically defined it, exactly what I mean in my specification, or I should have done a better job of going, okay, what does this word really mean? So part of the fun of being a patent attorney is being a wordsmith. We get to write, and we get to be really critical about the word and the terminology we use, right? So experienced patent attorneys, that was 17 years ago, right? Experienced patent attorneys are like, don't use essentially unless you, right? Anyway, that's an example of oops. Okay, so I'm getting a question, is it possible to get a recording of the session? Yes, we will send out a recording within a week to everybody who's registered for the seminar. And Idea to IPO will also eventually put it out on YouTube. And you feel free to reach out to me with the contact information that's on the slide right now. Gabriel asks, how much of the features of an invention can you disclose before you apply for a provisional patent? So a provisional patent application, the more, the better, right? And a provisional application might be early in your development, so you may not have everything, right? You can file a provisional application and then 3 months later file another one with adding another 5 pages, right? And then when it comes time to turn that provisional into a non-provisional, within 1 year of the first filing, you sweep all of your provisionals into one non-provisional, right? So often, and just a little while ago, I filed an application that was basically 3 pages of notes, right? And it was just blah, 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 this, it was basically outlines of claims with no support, no figures or whatever. I just wanted to get a date down, right? And I will, in another 2 months, file another application where I filled all that in and added the figures. But in between, I'm going to be talking, right, or the applicants can be talking with some consulting companies doing engineering, blah, blah, blah. They just want to make sure there's a record of this is what we had at this time, right? And the cost of a provisional, of that first provisional is really, you know, just a couple $100. So it was worth getting filed. The weakness of provisionals is not having enough material. So as you come up with improvements or refinements of your design, don't hesitate to add pages to the original document and put another cover sheet on it and refile it and build up those timestamps at the patent office, because it's a first to file world, right? And hopefully, in provisionals, I like to start with a claim and make sure that the description in the provisional application supports all the claims that I have. And that way I know that the provisional is covering my hopefully future claims, right? So that's it. Gabriel, put in as much as you can right now, okay? And then if you don't have everything, add more later and you'll get another filing date and you'll have 2 provisional applications that'll eventually turn into 1 non-provisional to start with. And then maybe someday a whole family and there'll be 20 of them, right? Okay, Jean says, does prior art have to be patented? No. Prior art is anything. It could be, it's usually written material. It could be publications, blogs, a student thesis, books, scientific articles, engineering content, a competitor's advertising material, everything, worldwide, okay? It could be in Japanese, right? One of the things about searching is if somebody filed a patent application last month, if it publishes, it's gonna not publish for maybe 18 months, maybe depending on the circumstances. So there's a lot of, and it gets priority from the date it was filed. So if I do a search today, I won't find that application, right? Even though it's called secret prior art, right? Even though it's going to be used against my patent application. So there is a limit to searching, right? A good search, if I go to one of the better search companies, I'm going to spend $6,000, 7 or 8 maybe, on finding search, and doing a search. If you're a company that's being sued, right? The good quality search company will do a worldwide search. They will have somebody, in 4 or 5 different languages doing searches in different countries, right? Finding prior art that can be used to challenge the patent that's being asserted at you. And that costs a lot of money, but it can really be good because nobody ever does, there's no search is ever complete, right? So there's a limit to searching. Most of my clients, not all, but most of my clients don't do searches prior to filing the patent application, a non-provisional. Some of them will file provisionals and then maybe 8 months later do a search. And then based on that search, decide whether or not to file the non-provisional application. And it's usually, sometimes it saves them a bunch of money, but it's often a wash, right? They do relatively inexpensive searches, maybe $800 or $1,000. So that means, if 1 in 20 of the times it prevents them from doing more, it's worth doing the search. But the searches are done by outside contractors. But you can search yourself. If you search yourself, keep a record of what you found. Go to patents.google.com. And with a scientific background, right? I consider it, especially if you're a startup, right? I consider it like reading the literature. Go and find out what your competitors are doing. Look at what their patents are finding. Look at the competition. It might be you see something, you go, that's kind of nice, but they don't have my secret sauce. If my secret sauce plus what they're doing together was really cool, right? And so all of a sudden you're going to file a patent where your contribution is an improvement, or patent application, where your contribution is an improvement on what they're doing. And basically you're going to block them from making that further improvement, giving yourself a commercial advantage. If they're a big company, they may want to acquire you because you've got a whole bunch of technology, of IP that is right in the middle of their product pathway, right? So that's kind of a nice try. I encourage people to look. If you work for a big company, right? If you're working for Intel or AMD, you don't want to do searches so much. Those companies discourage it because once they find out about a patent, it adds liability to them, right? If they know about a patent that could be asserted against them, the damages against them could be higher. So people at large companies, be sure to talk to your legal counsel. It's generally not so much a good idea to do searching, especially just general searching, but for patents. But if you're a small startup and you're nimble and you find something that's in your way, you can engineer around it, you can try to license it, you can work on something else, right? You haven't committed the whole company to it yet. So I encourage people who are in startups to do as much searching as possible, get to know the landscape, get to know their competitors. Okay. Dale is asking for copies of the presentation slides. Yes, they will go out along with a link to the recording. Somebody's asking, how much does a typical software patent cost? Okay, so in some of my other presentations, I give actual numbers, and I'm going to give stuff out. This is ballpark. Okay, I do, right, and I'm a Silicon Valley type patent attorney, right, based in Tahoe, but a lot of the time in San Francisco. I do for clients a provisional application for $2,500. And that includes me doing an hour and a half of disclosure with them to find out about the invention. Me writing a set of claims, maybe a few paragraphs of summary, maybe some simple block diagrams, right, if it's a software, and taking the claims and making an outline of them and telling them to fill in the detailed description with this outline. And the purpose of doing it that way is so that we know that there's enough description in the detailed description to support the claims. Okay, and that gives you a pretty meaty provisional application, and it can be done on a straight budget, on an amount that any startup should be able to afford. If they can afford that, they are going to run into lots of other troubles other than patents, okay? Because they're going to have costs, and their investors will see that they have no cash, and they'll get a bad deal, right? They'll be held over a barrel. The non-provisional application, it depends on the size, right? A small application is the cost is in the attorney's writing time. So if it's a 20-page patent application or a 40-page patent application, it's about almost double, right? There's doing the actual filing is 45 minutes maybe. There's a filing fee from the patent office, which depends on your filing status, but could be maybe $800, $900, depending on the number, a bunch of factors, but yeah. So I write a patent application. It usually comes out to about $600 per page. And that means the figures and double-spaced 8.5 by 11 pages, right? And that gives you a pretty good ballpark. So if I have a client that has provisional applications and they want a budget for filing a non-provisional application, I tell them, depending on, again, the size, but having a budget of maybe 18,000 to 20,000 would be reasonable. That's for your first one. Now, remember I talked about these continuations apart. That's for the root of a family of patent applications. That patent application, that specification, you could now take and add 5 more pages to, like, oh, we have another idea here. There's another way of doing something. Add 5 more pages to it and file it as a daughter continuation and part application. Now that is going to cost like $3,000 or $4,000 because we get to reuse everything, right? So the first one is usually most expensive, and then we build a family of patent applications. And I have looked at in my own case at when we have for a client maybe 20 applications on file, and the average cost for getting them on file is about $9,000 to $12,000, including the filing fee, right? That's over a whole family of applications. Keep in mind that that's to get the application on file. 95% of the time, an application is rejected the first time, okay? And again, you can look at some of my other presentations to get more details about this. But the patent attorney then has to argue why the examiner is wrong, or adjust the claims, explain the differences between the prior art, that the examiner citing and the invention, or work on it. And so on average for the patent office, before patent issues, there's something like 1.8 or 1.9 of these office actions. And they can cost really roughly $5,000 a piece. So by the time you get your first patent as a startup, you might have spent 30 grand on it over 3 to 5 years. If you're an early stage starter raising your first $500,000 or $1 million, I tell you to suggest that a reasonable IP budget is maybe $35,000 to $50,000 for the first year. And that will get you the core patent application. I'm assuming you already have provisionals, your core non-provisional, and maybe a couple of other daughter applications all filed within that first year. So that's just for budgeting purposes. It varies extremely. I have clients who are experienced attorneys or writers who give me the application to file, right? And they've done 30 or 40 of them, right? Before I became a patent attorney, I was a CTO. I spent most of the 90s as a CTO of a scientific instrument company. And I was writing, my first interview at a law firm was, and this is before I was an attorney, they were hiring me as a writer, as a patent drafter. I just showed them a stack of patent applications and they asked me if I could start that afternoon, right? So it can be done yourself. I look back at those and I kind of laugh, right? But it really makes a difference. Like the example I give, like essentially that word, right? I've fought over that for years, right? Having somebody who's really experienced is helpful. Some patent attorneys focus just on, integrated circuits or on car engines, right? There are patent attorneys that specialize on specific things. I know a patent attorney who does nothing but neural networks, right? I pretty much do everything under the sun but drugs. I don't do pharmaceuticals. My background, my PhD is in analytical chemistry, which means chemical, analytical means building instruments, right? So lasers, electronics, firmware, software programs, tons of software, controller systems, data analysis, that's all my backgrounds. So I pretty much cover everything from, today I'm going to do an app relating to a keyboard for iOS, and I'm going to do something for Oculus, right, the AR, VR. So it's everywhere all the time. It's really fun because I get to do so many different things. Okay, moving on, sorry. Somebody invented a way to produce software faster. This is Gabriel, and cheaper. So you're talking about worldwide patents. So filing outside the US is expensive because it involves a US attorney plus a European patent attorney or a Chinese patent attorney. You will probably end up filing in 3 or 4 countries. You will own the US, you'll do a European application, which will eventually be a patent in individual countries, and you'll do maybe Korea or Japan, or depending on where your field of software is, China or something. Okay. You aren't going to do worldwide. The only people who do really lots of worldwide are pharmaceutical companies. Your goal will be to file in places where your sales are going to be, where your potential acquirers are going to be, right? And where your competitors are, right? And that is not, you're not going to go. I remember when I first started my career, there was a company that was doing international exchange, and they filed in like 45 countries. And I'm sure it cost them this is 20 years ago, it probably cost them 40,000 a country, right? It just doesn't make sense. So you will end up you won't not have protection in Egypt or in Belarus right now. Okay, you probably won't file in Russia at the moment. So you won't have worldwide, but you will have the major markets, and your competitors will go, oh, we could do this in places except for here and here and here. That's not worth it, right? So that's how the system works. Okay, we have a question. Let's consider a startup context with patent. You said the patent litigation is expensive. What value of a startup is usually startup can't not spend 3 to 4 million? Yeah, a startup can't spend 3 to 4 million against a big player. Keep that in mind. The patents are important for startups, but they're to increase your valuation. I want you to imagine you're doing your A round fundraising, right? You're raising $15 million at a $50 million value of the company, okay? And you're in front of a bunch of really sophisticated investors. You're going to explain to them the 3 or 4 things that really have made your company successful, why your user growth or your sales are through the roof, and you're going to point out the things that differentiate your company from the competitors, right? And then you're going to have a slide, what I call a cluster map, that's going to show those 3 or 4 things, maybe it's bubbles, and all your IP around them, connecting the IP to the core things that make your company valuable, right? And that slide will convey the value of your IP portfolio to your patent, to your business, right? And again, my goal is every time you raise money or on your exit, I pay for myself many, many times over, right? I have had situations where there's going to be a purchase where an acquirer is looking at my client and it's somebody else. And fortunately, my client won, partly because of the IP, partly because my client's CEO was a really nice guy, easy to work with, and really smart, and the other company wasn't anywhere near that. And my client got about $400 million, and the other company went bankrupt. Okay, so it can make a really big difference. I have seen cases where a company has thought they were getting bought, right? And they're working with Microsoft. I'm going to name Microsoft here. And they are doing a deal, checking time. Oh, sorry. They're going to do a deal with Microsoft, and they've explained everything. And so all of a sudden, Microsoft goes silent, and a week later produces exactly, launches a whole new Microsoft product based on their ideas, right? That company turns from a 40-person software company into a patent enforcement agency. Fortunately for them, the damages are now huge. Microsoft's going to get rung over the coals, and that is, and they can hire attorneys and they can get financing to pay for that money. But they're unfortunately now a patent enforcement company, and they did, in the specific case I'm thinking of, they got money. They got some nice money out of Microsoft, but it was not as near what they would have gotten as a, an acquisition, right? So that's why you want to do patents. You want the acquirer to decide they want to buy you instead of duplicate you, right? Hopefully you have more than one. If Samsung and Microsoft and Facebook are all looking at your AR technology, right? They'll buy you for your engineers, for your customers, and for your IP and all the other assets of your company. Make the IP one of those things that adds value. And that's why it's important that startups have a good IP portfolio. Okay, now, one more. So when you're pitching early on and you're getting your seed money and the investor says, well, what about the competition? Don't give them the answer of, oh, I have a provisional filed, I don't have to worry about the competition. Because that provisional won't be a patent for 5 years, and by then you might have exited, right? Or you're not going to be, and I've had people, individual investors come up to me with a great patented garlic crusher, right? And say, the guy down at the trade show just knocked me up and I can't do anything about it. I have this patent. And it's like, well, how much do you sell of this a year? And he's like, 60,000. Well, the patent isn't going to be useful, right? Sell it to a company that makes kitchenware and they'll enforce it. But that's it. I have seen other cases where individuals do enforce their patents. And I've seen, I've worked with a company, I work with a company that helps individual investors. It's a nonprofit. And they do the strategy of filing a provisional, seeing if the product gets traction in that first year, and then deciding whether to spend the real money on the patent application. But it can be enforceable, and often those individuals sell their inventions to a big company, and the patent portfolio makes a big difference. Okay, I am way out of time. I'm sorry, folks. I knew I was going to run over. Okay, a couple more questions. Can you give us a quick take on pending legislation? No, I'm not going to do that. I'm not up on it. Yeah, that would be a whole nother talk and off topic. The legislation is literally sausage. So anything that's pending, I don't believe until it actually comes out. That's my experience, right? And then I'll dive into it. Our product is on the market for a couple of years. We use proprietary technology, but we didn't patent it. Can we patent it now? No. The part of whatever's been on the market for a couple of years, it's now too late to patent, right? In the US, you have 1 year between public use or disclosure before you have to file, but in the rest of the world, there's no grace period. What you ought to do now is look at your product and think about your product pipeline over the next 5 years, where you're going to take it and what improvements you might make in it, and then patent those, okay? Start looking at the incremental improvements and try to get patent coverage on those, right? CW asks, examiners, I've heard that especially for startup without megabucks, the SIME examiner is a crapshoot. Well, yeah. Some examiners are perceptive, most of them, they try. I know a lot of examiners, so friends who went from law school to be an examiner, or were examiners, and it used to be the patent office would pay for your law school. While some either newbies or whatever. Yeah, if you have an examiner that is a problem, that encourages you to take things to appeal and go through the examiner supervisor more, escalate things quickly. Sometimes you can teach, I mean, the goal of your attorney is to teach the examiner, explain, to have lots of interviews. There should be ways to get things efficiently done. But bring the supervisor in a bunch. When they're making really silly mistakes, then that's not good. Anne is asking, if you subsequently add new things to a provisional application, will your effective date of claim be different from? Yes. So you get credit for a new idea on the day it was included in a provisional. So your first provisional doesn't have that idea, that filing date doesn't matter to that particular conception or that idea. Your third provisional has that idea in it. That idea has priority date of that third provisional. So it can get kind of complicated if you have a bunch of provisionals, right? And so again, for the continuations in part, right, this is a non-provisional. You might add a page or two to the specification and file it. The new material only gets that new filing date, not priority all the way back. Okay, the recording will be emailed out in the next week, a link to it, everybody who registered, and that's it. I am way over time. I have to figure out how to shorten this talk down. I appreciate it. I want to thank IDEA to IPO, and please reach out to me by email or on LinkedIn. I read my email more than my LinkedIn, but that's it, folks. Thank you very much. I appreciate your attendance.